if, number one, evidence shows that a felony actually occurred. Number two, the fleeing suspect against whom force was used was the person who committed the felony. And three, the use of deadly force was necessary to ensure the apprehension of the felon. For purposes of the questions before us today, it is clear that even under this broad and rather forgiving rule of justification, the question of necessity remains tightly wound around its core, requiring an answer to the question of whether the actions of the police officer were reasonably necessary under the circumstances to ensure the apprehension of the felon. And no different than the necessity component at the core of self-defense, necessity to ensure the apprehension of the felon is a question of fact for the jury to decide. In applying the probable cause standard, there is at least some evidence from which a person of average intelligence could conclude that defendant's shooting of Lyoya in the back of the head was not reasonably necessary to prevent his escape. As the prosecutor suggests, at the instant that the shot was fired, Lyoya is not in a position of actively escaping or fleeing. A reasonable juror could find a lack of necessity for deadly force strictly for the purpose of preventing escape. Therefore, for the foregoing reasons, the court concludes that as a matter of law, probable cause has been presented to support the charge in the criminal complaint. Accordingly, it is the court's legal obligation to bind defendant over to the 17th Circuit Court to stand trial on that charge. And that is the end of the court's opinion. Mr. Bergola, does your client wish to waive circuit court arraignment at this time?
We do, Your Honor.
Okay. Then if you would execute the written waiver. Is there anything else we need to address before the court adjourns?
Nothing for Your Honor. Nothing to defense, Your Honor.
Okay. Then the court will sign the order binding defendant over to the circuit court for trial. Once the court signs that order, this court will no longer have jurisdiction of this matter. Bond is continued at this time. I want to thank, again, counsel, staff, and everyone in the media, and everyone that was here, and everyone that has a strong interest in this matter, for your respect, for your courtesy, for your patience, while this procedure and process played itself out. I do want to wish everybody here, everyone who has been touched by the facts and circumstances that were presented over the past couple of days, the peace, hopefully that you find peace in the coming days, regardless of what those coming days may hold. Thank you, everyone. Take care. We are adjourned.